All right. Oops. Good morning, everybody. Good morning. Good morning. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the entity, the school that is offering this course for CE credit. This course is Know Who is Protected under Fair Housing and what the laws are. It is Georgia Real Estate Commission CE course number 62099. So we are going to get started in just a second, and I am going to start off by, I'm going to share my screen, and we are going to get started. The course does not count for license law. You guys, the only course that counts for license law is a course that says license law in the title. Because the Georgia Real Estate Commission does require that course for every licensee in Georgia, it is in the law what a school does have to offer in that course. So there is a license law course. We offer it through the Georgia Real Estate Academy, and many other schools offer it. This class does not satisfy that license law required course. All right, so today's course, again, please continue to ask your questions through the chat button. And again, I will answer them if you want to unmute yourself at the break and at the end. But if you stay muted now, it helps everybody hearing the class. So, and we are recording. All right, so notice to students for the virtual broadcast of continuing education classes of the GREC approved classroom class. There's only one law class. In other words, there is a class that is categorized by GREC as license law, but there are a myriad of classes that are offered by different schools. So a different school can have a class named something differently. For example, the law class that we teach through the Georgia Real Estate Academy is called License Law for Agents and Brokers. I don't know what other schools have their law class named, but there's only, but it would be categorized by GREC as a law class, and you'd have to ask the school. All right, this class, we've got to get started. Know who is protected under fair housing and what the laws are. This is the Georgia Real Estate course number 62099 through our school. This is a virtual remote broadcast of an approved in-class course. It's 3 hours in duration and approved by GREC for the purpose of CE. There are no prerequisites to receive credit for this course. I'm the instructor. Again, my name is Dana Sparks, and there is no required homework or written exams. You must be on time and present for all the remote virtual broadcast instruction hours to receive credit for this course. The roll call and documentation of your license number is done, as we mentioned at the beginning, through the chat function at the beginning and at the break and at the end of class. You may only receive credit for a specific course number. So that is this specific course number that is offered through a school. So you could take another fair housing class through another school. It's not a topic once per 12 months. It's the actual course number once every 12 months that you will get credit for. There is no recruiting for employment opportunities for any real estate brokerage firm in the class or on school premises. If so, please report that to either GREC or myself, Dana Sparks, the director of the Georgia Real Estate Academy, or Heidi Kelly, who is the coordinator of the school. So we are going to get started. And this class is fair housing. Let me tell you guys, I just read the notice to students. You might, if there's anything interesting to you, feel free to take out your cell phone and take a screenshot of what you see on the screen. As I mentioned, there are handouts available to you as a reference after the class. You do not need anything for this class. Everything will be presented on this PowerPoint presentation. And one of the handouts available to you is a PDF version of the PowerPoint. So you'll have all of these slides available to you as well. And again, in the chat, I will once again put where you can go to find those handouts after class, and we'll walk through that again a little bit later. So you guys, fair housing is a huge, huge, huge topic. This class could go on for hours and hours and days and days. So the purpose of the content of this class that you're taking right now is basically a brief introduction of what the fair housing laws are for the purposes of you as a real estate licensee in the state of Georgia. This class is, CE credit is only available for your Georgia real estate license. Sometimes we get agents on from other parts of the country, and I welcome you to stay for the information, but the CE credits, the continuing education credits, are only going to be applicable to your Georgia real estate license because the school is not a designated school in any other state. But fair housing, there are federal laws and there are state laws. This class, we're just going to cover some of the laws and what they are. I'm going to give you some of the resources, and we're going to talk about the contracts and some of the Georgia contracts that you have availability to and how they apply to that, as well as some information about assistance and service animals. But as I mentioned, there is just a ton of information on fair housing, and this by no means is a comprehensive class. I urge each and every one of you to take the initiative to go on your own and learn more about fair housing, take more CE classes, and research it on your own through the resources I will give you, especially if you are in property management or leasing or even doing tenant procurement, helping landlords put their properties up for lease and just doing tenant procurement. I urge you to learn as much as you can about fair housing. So we're going to start off with a quiz, not graded, but this is just a little pre-test for yourself to sort of check out your knowledge, basic knowledge on fair housing. This quiz is from NAR, the National Association of Realtors. So first thing, let me just make sure my volume is up. All right. All right, first quiz question. Under federal fair housing laws, it is legal to prohibit which of the following in a housing unit? Smoking, a live-in caregiver for a resident with disability, drinking alcohol, or both A and C? Type in your answer in the chat. A, B, C, or D? All right, lots of A's, lots of A and C, lots of D's. The correct answer is D, both A and C. It is legal to prohibit smoking and drinking alcohol in a housing unit. All right, number 2. Which of the following are violations of or potential violations of the Fair Housing Act? A seller tells you he doesn't want to sell to African Americans. B, a sales associate puts the phrase adults only in an MLS listing. C, both A and B, or D, none of the above? Lots of C's. A, B. All right. The answer is C, both A and B are violations or potential violations of the Federal Fair Housing Act. Number 3, under the Federal Fair Housing Law, the 7 protected classes include A, race, color, source of income, handicap, national origin, marital status, religion. B, race, color, religion, sex, handicap, familial status, national origin. C, race, sexual orientation, sex, familial status, handicap, age, national origin, or D, none of the above? A little bit later in the class, I'm going to teach you guys a really, really easy way to remember the 7 federally protected groups. B, C, D. I think sexual orientation's throwing you guys off. What do you think? A, B, and C? All right, Anna, try re-registering or try getting on from another either computer or a phone or a laptop. All right, the answer is B, race, color, religion, sex, handicap, familial status, and national origin. Number 4, the fair housing laws prohibit all of the following except A, refusal to show, sell, or rent a property because of a disability. B, expressing a preference for young adults in a listing comment. C, evicting a current user of illegal drugs. D, marketing your listings exclusively in a religious publication. Familial status, familial is an adjective that means family. So familial status would mean, generally speaking, it would mean if you're single, if you're married, if you're divorced, if you're living with someone, if you're pregnant, if you're not pregnant, if you have children, all of that is subsumed under the term familial status. Again, familial is the adjective form of family. Correct answer is C. You can evict someone who is currently a user of illegal drugs. All the rest you cannot do. All right, number 5, the Civil Rights Act of 1866 does which of the following? A, grants all citizens the same rights as white citizens to own, purchase, lease, transfer, or use the use of real property. B, allows exemptions only for homes sold without the assistance of a real estate practitioner. C, effectively prohibits all discrimination in real estate based on race. D, both A and C. The answer is D, both A and C. Number 6, based on federal fair housing laws, which of the following people would be protected? A, a divorced female single parent. B, a 35-year-old single Jewish man. C, a 50-year-old white man. D, all of the above. And the correct answer is D, all of the above. You guys are doing awesome. All right. When a prospect inquires about the racial makeup of neighborhoods or schools, you should respond by saying, A, I believe the neighborhood has a few Hispanic families. I can check and get back to you. B, the Fair Housing Act prohibits me from providing that kind of information. I recommend you contact the school district, municipal government, or the local library. C, I wouldn't worry about that. The neighborhood is safe and the schools are good. D, residents in the neighborhood value diversity. You'll fit right in. So when a prospect inquires, you as a real estate agent, how should you respond? Yep. Correct answer is B. The Fair Housing Act prohibits me from providing that kind of information. I recommend you contact the school district, municipal government, or the local library. And number 9, if a seller using a real estate agent refuses an offer because of the buyer's national origin, who may file a federal lawsuit against the seller? A, the prospective buyer. B, the real estate practitioner. C, the federal government. Or D, all of the above. Ooh, lots of different questions on this, lots of different answers on this one. All right, the correct answer is D, all of the above. You guys, federal and state fair housing laws are laws to which you as a real estate agent, as well as your public people, must adhere to. They're laws of the state and federal laws, just like any laws are. All right, number 10, looking at the following 4 marketing examples, identify which one is okay. A, Advertise only in a strategic limited government area that is populated by a particular ethnic group. B, limit advertising to small papers which cater to particular religious groups of people. C, promote a listing only in the selected sales offices in communities with similar ethnic populations. D, advertising your knowledge of a language other than English in an English language advertisement. The correct answer is D, advertising your knowledge of a language other than English in an English language advertisement. All right, number 11. In an ad for a small 2-bedroom house in a neighborhood where many families live, which of the following language is improper under the Fair Housing Act? A, small, cozy home in quiet neighborhood. B, 2-bedroom home near playground and senior center. C, close to award-winning schools. Or D, no children. Which one is improper? Yep, you guys are doing really well. The answer is D, no children. And 12, which of the following features are required in ground floor units of non-elevator multifamily building of 4 units or more built after March of 1991? A, an accessible building entrance or an accessible route for people in wheelchairs. B, accessible and usable public and common areas. C, light switches, electrical outlets, thermostat, and other environmental controls in accessible locations. Or D, all of the above. And the correct answer is D, all of the above. How'd you do? You guys did really well. I think y'all did really, really well. All right, now moving on. Does the equal housing opportunity symbol appear in your marketing? It's not required by law. It's just an outward sign that you provide equal housing opportunities. Now, your broker may have a policy requiring it on all your marketing, but it is not required by the Federal Fair Housing Act. The only time it is required is if you are marketing a HUD home, which is a house that where the buyer had an FHA insured loan, went into foreclosure. It goes back to the Department of Housing and Urban Development. And if you are marketing that house, HUD requires that you use the equal housing opportunity symbol. So other than HUD requiring that to market their homes or your broker, it's not required. So the protected classes under fair housing, it is your responsibility to know. Also, it is a good point of practice to educate your clients. There is a HUD pamphlet available if you go to www.hud, and again, HUD stands for the Housing of Urban Development.gov. There are 7 federally protected classes. So before we get into those, question, is sexual orientation a protected class? What do you think, yes or no? Let me break that down. Because as I mentioned, there are federal laws and there are state laws. So is sexual orientation a protected class federally? Is sexual orientation a protected class in the state of Georgia? Lots of yeses, lots of nos. Ha! The correct answer is federal law does not protect people against housing discrimination based on their sexual orientation. However, the District of Columbia, several cities and towns, and the following states do include sexual orientation as a protected class in their housing discrimination laws. Georgia is not one of them at this point in time. Interesting, isn't it? Note, there is, in 2017, however, there is a ruling by a federal judge that sexual orientation and gender identity are protected classes. So that is, there's a federal ruling that if this gets argued in court, I would imagine an attorney is going to point to that federal ruling. But as labeled as a quote unquote protected class, as of right now, the government has not added sexual orientation or gender identity. But again, there is that federal ruling. Now, what about age? Is age a protected group? What do you think? This is a trick question. Some say yes, some say no. Yes, no. Ooh, Lee Davenport. Ha. All right. The Federal Fair Housing Acts do not expressly ban discrimination based on age. Nevertheless, it is definitely forbidden under the broader prohibition against discrimination on the basis of familial status. So age in and of itself is not a specifically protected group. Now, the mortgage laws are completely different, but we're talking about fair housing as they apply to dwellings. So then you should be scratching your head saying, well, what about active adult communities? And Lee, you are correct. First of all, backing up a little bit, under familial status, the Fair Housing Act, with some exceptions, prohibits discrimination in housing against families with children under the age of 18. In addition to prohibiting an outright denial of housing to families with children, the Act also prevents housing providers from imposing any special requirements or conditions on tenants with custody of children. We're seeing a lot of people who don't necessarily have their own children, as that term is defined by somebody under the age of 18. Nevertheless, they are having custody of, generally speaking, their grandchildren or foster children or adopted children. So, for example, landlords may not locate families with children in any single portion of a complex, place an unreasonable restriction on the total number of persons who may reside in a dwelling, or limit their access to recreational services provided to other tenants. In most instances, the amended Fair Housing Act prohibits a housing provider from refusing to rent or sell to families with children. However, some facilities may be designated as housing for older persons, which is considered 55 years of age or older. This type of housing, which meets the standards set forth in the HOPA Act of 1995, Housing for Older Persons Act, may operate as quote-unquote senior housing. HUD has published regulations and additional guidance detailing these statutory requirements. There is a link there, and in the handouts available to you after class, I do have a sheet on questions and answers regarding active community, adult active community properties and the HOPA Act of 1995. So let's think, well, what actually are the protected classes? Here's a mnemonic to help you guys remember, so you'll always remember what they are from this point forward. Just remember fresh corn. These are the federally protected groups. F stands for familial status. R stands for religion. Nothing for E. S stands for sex, and that refers to gender. That's an adjective, not a verb. H stands for handicap status or disability. C stands for color. Nothing for O. R for race, and N for national origin. So if you read the letters down the side going from top to bottom, you get fresh corn. Familial status, religion, sex, handicap status or disability, color, race, and national origin. There's no E or O, just remember equal opportunity. All right, so going on, what about discriminating against sexual orientation in our state, in the state of Georgia? Well, if you are an agent and you sign, or a public person signs, a brokerage agreement, which is a listing agreement or a buyer brokerage agreement, or this is also true on the customer agreements, authorization to show unlisted property, as well as the customer acknowledgement on either the Georgia Association of Realtors forms, and I apologize, this is also included in the RE forms under their listing agreements and buyer brokerage agreements, The GAR form is F101, which is the exclusive, and F104, which is the non-exclusive listing agreement. And for buyers, the GAR form F110 is the exclusive, and F113 is the non-exclusive buyer brokerage agreements. There is a fair housing disclosure pre-printed on those forms that you as an agent and your broker, as well as your public people, agree to when they sign those documents. And it states the seller acknowledges, or in the buyer brokerage, obviously it's going to say the word buyer, acknowledges that a broker is committed to providing equal housing opportunities to all persons, and that seller / buyer and broker are obligated to comply with state and federal fair housing laws in selling the property. Seller and broker agree not to discriminate in the sale of the property on the basis of race, color, religion, national origin, sex, familial status, disability, and sexual orientation or gender identity. So pre-printed in our contract forms are sexual orientation and gender identity added. Again, this is also true in the RE forms, buyer brokerage and right to sell listing agreements, and the fair housing disclosure in those forms specifically states the undersigned seller and broker, and again, it will say buyer in the buyer brokerage agreements, by their respective signatures herein agree they will not discriminate against any prospective buyer or seller because of race, color, sex, religion, handicap, familial status, national origin, gender identity, or sexual orientation of such person in accordance with the applicable federal and state laws. Now, what about discriminating against sexual orientation as a realtor? So you are a realtor if you belong to a local board of realtors. If you belong to a local board of realtors, then part of your dues money also goes to the state level, and that makes you a member of the Georgia Association of Realtors, or GAR, and part of your dues money goes to the national level, NAR, which is the National Association of Realtors. Once you are a member of NAR, the National Association of Realtors, you are allowed to use the term realtor as associated with your work. That term is a copyrighted term protected by NAR and may only be used by real estate practitioners who are a current member of NAR. If you are a member of NAR, then you must adhere to the NAR Articles of the Code of Ethics. And Article 3 of the Realtor Code of Ethics states that realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include the obligation to share commissions, fees, or to otherwise compensate another broker. However, Standard of Practice 3-11 under this article specifically states that realtors may not refuse to cooperate on the basis of a broker's race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Yes, if you are a member of NAR in one state, you are a member of NAR in another state, but that NAR membership does get renewed annually. So at the end of the year, you must join another board of realtors to continue your NAR membership. There are no lifelong or grandfathered in agents. All right, fair housing terms and agencies. There are a lot of agencies that have their hand in fair housing laws. FHA, that stands for Fair Housing Act, not FHA when you're thinking of loans. This is a different acronym, not an acronym. This is a different for FHA. It stands for Fair Housing Act. The ADA stands for the Americans with Disabilities Act. HUD is the Department of Housing and Urban Development. FHEQ stands for Fair Housing and Equal Opportunity. HP stands for Housing Provider. So here is an infographic of fair housing trends in 2019. And just to give you guys a sense of fair housing, there were close to 29,000 reported acts of housing discrimination across the entire United States. Almost 7% of those were comprised of sexual discrimination cases, And of that 6.75%, 204 is the highest rate ever recorded of cases alleging sexual discrimination. From 2018 to 2019, so just in a year, harassment based on sex increased by almost 47%, from 139 to 204. Of the complaints brought, fair housing complaints brought, the majority of them were based on a discrimination against the protection against disability as that group, almost 59%. You can see the other percentages of the breakdown of complaints. 6.75% sex, 7.71% familial status, 2.24% color, 10.79% other, just under 6% for national origin, 1.14% for religion, and 16.47% for race. Now, check out this next figure. The complaints by transaction type. By far, the majority of fair housing complaints are based on transactions involving rentals. That would include property management as well as lease procurement. Of the other ones, 2.70% is based on sales, less than 1% for lending, less than 0.07% for insurance, 2.64 harassment, 0.42 ads, HOAs is almost 0.5%, and other is 9%. So the thing is it is still, the laws are still in effect regardless of the type of real estate that you practice. Even if you practice housing or new construction, you still must be aware of and cautious of not violating the Fair Housing Act. So what are some signs of discrimination? Well, there's some very obvious ones and there are some less obvious ones. An obvious one would be refusing to rent or sell to someone due to their disability. Sometimes, however, a disability is very apparent and observable. Sometimes a disability is not apparent and observable, and you could inadvertently be committing discrimination without knowing that somebody does have a disability. If a person is charged extra fees or higher fees or different fees, refusing to permit modifications to a property such as ramps, being told a property is not available when it actually is, refusal to allow assistance animals due to a no pet policy, being asked if a public person is asked to provide a medical history to provide that they have a disability. So I'm going to start off with a really short video that is fairly obvious, but it. All right, so the Fair Housing Act, which is also Title 8 of the Civil Rights Act of 1968, introduced meaningful federal enforcement mechanisms. It outlaws refusal to sell or rent a dwelling to any person because of, once again, race, color, disability, religion, sex, familial status, or national origin. It also requires that all federal programs relating to housing and urban development be administered in a manner that affirmatively furthers fair housing. It came into effect April 11th, 1968. To this day, the real estate community always celebrates April as Fair Housing Month, and obviously in 2018, we just we just celebrated the 50th year of the enactment of the Fair Housing Act. There is, I see a question about, are you allowed to limit the number of people in a rental? Let me go ahead and address that now, because you have to be very careful. The careful part you have to be cautious of is you have to watch out that you're not showing a discriminatory preference towards or against any sort of national origin because of any cultural preferences for having a lot of people live together in one house. but I did consult with an attorney. This question came up specifically, and let me tell you what I got from an attorney. And the attorney I got this from, hang on, I'm looking to read her actual handout. I'm sorry, give me 2 seconds. Okay, hang on. Okay, hang on, let me look one more place. All right, I'm gonna continue on and look for that. Well, hang on 1 second. All right, I'm looking for that to read to you. I thought I had it in my handout, so give me 1 second. Okay, here we go. I found it. So this is from attorney Christina Adams, who is a closing attorney with the Hartman Law Firm in Woodstock, Georgia. Actually, they've got various offices all over. And the answer was brought up is, can a landlord limit, the question was brought up, can a landlord limit the number of children that would be renting a property? And this is a little bit of a tricky question. No, a landlord cannot refuse if it's due to a family having 5 children. But, ... there's always an exception. The exception is maybe, if the question is, can a landlord refuse to rent a 3-bedroom home to 7 people? Generally, the rule of thumb is 2 people to a bedroom based on the Keating memo, which is a memo issued by the Department of Housing and Urban Development. It's not a hard and fast rule, just a guideline. Does the home have 3 bedrooms, but also are there other rooms that could be used as a bedroom? For example, a den, a separate living room, so forth and so on. Now, there's a difference in how an appraiser is going to look at that room when selling a property, listing the number of bedrooms, versus when someone is renting a property. And the Keating memo issued by HUD does look at, are there other rooms that could be used as a bedroom? As I mentioned, a den, separate living room, etc. Is one of the bedrooms extra large and therefore could reasonably house 3 people? It could work the opposite way as well. Is one bedroom so tiny that it's really only usable for 1 person? There are state and local codes that can also be helpful, and there are other additional factors such as septic or sewer capacity that should be considered. Some companies adopt a standard of 2 per bedroom plus 1. A 1-bedroom unit could have 3 occupants. A 2-bedroom unit, for example, could have 5 occupants, etc. Limits should be decided in advance. A landlord or a housing provider should decide limits in advance of showing the property to tenants, and should be based on the number of people, not children. If you can't see me, I'm using air quotes. One possible exception would be that you might have a 1-bedroom that you could decide in advance to rent to 2 people maximum based on the size of the unit and the bedroom size. But if your tenants have a baby, an allowance should probably be made for the baby. Kicking out a couple right after the birth of their first child may be upsetting enough to lead to a challenge by a disgruntled tenant. Other things to watch with landlords: any discriminatory language, like the landlords specifically talking about having children, prohibiting 5 children versus 7 occupants, having designated areas of a multifamily building for families, or limited access to amenities for families. Again, that is from closing attorney Christina Adams of Hartman Law Firm. So again, there are the issue of fair housing is definitely an interesting one. All right, so moving along. What types of housing are covered? The Fair Housing Act covers most housing. In very limited circumstances, the Act exempts owner-occupied buildings with no more than 4 units, Single-family houses sold or rented by the owner without the use of an agent and does not use discriminating advertising. Housing operated by religious organizations and private clubs that limit occupancy to members. What is prohibited in the sale or rent of housing? It is illegal discrimination to take any of the following actions because of race, color, religion, sex, disability, familial status, or national origin. If you refuse to rent or sell housing based on one of those groups, if you refuse to negotiate for housing, in other words, if you're showing a discriminatory preference towards or against a public person based on one of these protected groups, it is illegal. If you otherwise make housing unavailable, if you set different terms, conditions, or privileges for the sale or rental of a dwelling, if you provide a person with different housing services or facilities, if you falsely deny that housing is available for inspection, sale, or rental, if you set different terms, conditions, or privileges for the sale or rental of a dwelling, if you provide a person different housing services or facilities based on one of those groups, if you falsely deny that housing is available, I already said that, sorry about that. If you make, print, publish, or cause to make, print, or have published any notice, statement, or advertisement with respect to the sale or rental of a dwelling that indicates any preference, limitation, or discrimination, if you impose a different sales price or rental charges for the sale or rental of a dwelling, if you use different qualification criteria or applications or sale or rental standards or procedures, such as income standards, application requirements, application fees, credit analyses, sale or rental approval procedures, or other requirements. If you use different ones of those for different applicants, if you evict a tenant or a tenant's guest, or if you harass a person. I see the question about what if a person has a disability, but you decline to rent to them for a reason other than their disability. You need to be extremely, extremely cautious that you can demonstrate that it is for another reason. I'm going to cover that a little more later on in the presentation when I get to points of practice for you guys as an agent to help protect yourself from being the victim of a case against fair housing. Continuing on, signs of discrimination. If you fail or delay performance or maintenance or repairs, if you limit privileges, services, or facilities of a dwelling, discourage the purchase or rental of a dwelling, assign a person to a particular building or neighborhood or section of a building or neighborhood, for profit, if you persuade or try to persuade homeowners to sell their homes by suggesting that people of a particular protected characteristic are about to move into the neighborhood, and the term for that is called blockbusting. If you refuse to provide or discriminate in the terms or conditions of homeowners insurance because of the race, color, religion, sex, disability, familial status, or national origin of the owner and or occupants. If you deny access to or membership in any MLS or brokers organization, those are all signs of discrimination. Persons not protected. So who is not protected under the Fair Housing Act? Juveniles and sex offenders are not considered persons with disabilities, and therefore not protected. Persons currently using illegally controlled substances. So if you ask on an application, are you currently using an illegal controlled substance? I'm not sure if you're going to get a truthful answer to that. But if a landlord does actually find evidence of a person currently using illegal controlled substance, that person is not protected under fair housing. But fair housing does protect persons recovering from substance abuse. Persons with disability whose tendency would constitute that should be tenancy, not tenancy, who's living in a dwelling, would constitute a direct threat to the health or safety of others, or if their tenancy would result in substantial physical damage to the dwelling. Direct threat must be based on reliable, objective evidence, not just fear or speculation or stereotype. So some of the common fair housing lingo, some of you guys, you're gonna have flashbacks to pre-license school where you first learned these. Steering, the process of influencing a buyer's choice of communities based upon the buyer's race, color, religion, gender, disability, familial status, or national origin. Blockbusting or panic selling, this was definitely more prevalent in the 50s and 60s. When an agent or developer induces people to sell or leave a neighborhood due to their prospective entry of a particular race or ethnicity into a neighborhood, or redlining, and that is when agents, lenders, brokers, or insurance companies stop doing business, just simply stop doing business in a particular neighborhood. In other words, they just quote unquote write off that neighborhood. What tenancy would pose a direct threat? That would be something if somebody is extremely violent and they destroy the property. If whatever their disability is, again, they have they're prone to actual physical violence, things like that. There are a lot of, that is actually defined very specifically, and there are a lot of tests and evaluations that if a landlord wants to evict someone or not rent to someone and it does go to court or it does get investigated by HUD, there are very specific tests that HUD would look at or an attorney would look at to help make that determination versus, again, fear or using a stereotype of, oh my gosh, someone has this sort of mental disorder, and I've heard that if they're in one phase or another of a particular mental disorder, they get extremely violent to either the property or other persons. But again, there are very specific. You guys are asking me very specific questions. PTSD. Again, these are questions that there are a ton of examples and evaluations and tests to determine if somebody is in violation of fair housing laws by either not renting or selling to someone with a particular disability or handicap, or if they evict someone or attempt eviction of someone based on a particular disability or handicap. And you guys saw in that infographic, the category or the status or the group of disability is by far the largest number of cases are based on that, because there are some very apparent disabilities that would fit into that category, and there are some non-apparent disabilities. So again, the point of this CE class is just to bring all of this information to your awareness so that you know when you and or a public seller and or a public buyer and or a public landlord and or a public tenant whom you are working with needs to investigate these issues more specifically with any specific issue that comes up, such as PTSD. And again, we're going to get into the animals a little bit later on in the presentation. All right, what about the Georgia Real Estate Commission license laws? How do those affect you guys as an agent with respect to fair housing? Well, again, we've already talked about fair housing laws are federal laws and state laws. Now, with respect to your real estate license, there are also a whole body of license laws. One, for example, is it is housed under the unfair trade practice laws, which is Official Code Georgia Annotated 43-40-25, that basically states, because of, again, those protected groups, it is a violation of unfair trade practices if you refuse to sell after the making of a bona fide offer, or refuse to negotiate for the sale, or otherwise make unavailable or deny real estate to someone based on those groups. If you discriminate against any person in the terms, conditions, or privileges of the sale of real estate or in the provision of services or facilities in connection therewith based on those groups, if you make, print, publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to the sale of real estate that indicates any preference, limitation, or discrimination, or an intention to make any such preference or limitation or discrimination. If you represent to anybody that real estate is not available for inspection or sale when it is, if you represent explicitly or implicitly that a change has or will or may occur in a block, neighborhood, or area in order to induce or discourage the sale of real estate. In other words, if you do any of those, your real estate license is in jeopardy as well. And there could be a sanction or a revocation or of your real estate license or a suspension. Other prohibitions. In addition, it is illegal discrimination to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right or assisting others who exercise the right. And it's illegal to retaliate against someone who's filed a fair housing complaint or assisted another person in a fair housing investigation. Now, on top of the Fair Housing Act, what about just other protections for people with disabilities? Again, that disability category is the largest category. Housing providers must make reasonable accommodations and allow reasonable modifications that may be necessary to persons with disabilities to enjoy their housing. And again, you guys, regarding making reasonable accommodations, a lot of this really is more applicable to someone who is renting a property or properties or a landlord, as opposed to the sale of a property. There is much more information about reasonable accommodation at HUD.gov. Certain multifamily housing must be accessible to persons with disabilities. And now let's talk about advertising and marketing. Moving on. In nearly all housing, including private housing, public housing, and housing that receives federal funding, the Fair Housing Act prohibits the making, printing, and publishing of advertisements that indicate a preference, limitation, or discrimination because of the protected groups of race, color, religion, sex, disability, familial status, or national origin. The prohibition applies to publishers, such as newspapers and directories, as well as persons and entities who place real estate ads in newspapers and on websites. It also applies where the advertisement itself violates the act, even if the property being advertised may be exempt from the provisions of the act. Other federal civil rights laws may also prohibit discriminatory advertising practices. So, examples of some advertising violations, including the phrase such as no children, which indicates a discrimination based on the basis of familial status, or no wheelchairs, which indicates a disability discrimination. Perfect for the growing family, ideal location for joggers. Those are more than likely violations of fair housing in your marketing and advertising. Growing family, again, could show a discriminatory preference against someone that can't have a family or that doesn't have a family. Ideal for joggers could be interpreted as showing a discriminatory preference against someone with a physical disability preventing them from jogging. GREC advertising laws, which is GREC Rule 520-1-.09, part of their advertising law states that a licensee shall not advertise to sell real estate when such advertisement is directed at or referred to persons of a particular race, color, religion, sex, handicap, familial status, or national origin. And the contents of any advertisement must be confined to information relative to the actual real estate itself and any advertisement that is directed at or referred to persons of any particular, rather than directed at someone within one of those groups. In other words, you guys, here is your point of practice. You want to describe the property and not the person. So let's go back here to this slide. You don't want to say perfect for the growing family, because that describes a potential person who would or would not be comfortable living in that property. Ideal location for joggers describes a person who you think would or would not enjoy living in that property. Instead, you could say this house has 7 bedrooms and 20 bathrooms. Or you could say this property is located next to the Silver Comet Trail. You have to describe the property itself, not the person that you think would be ideal for living in that property. I've got another, this was filmed, this YouTube video was filmed a while ago, but it is really a good video to help you guys with your marketing with respect to fair housing. So again, best point of practice is really just to remember to describe the property rather than the person. And for those real estate agents who have been practicing for over 20, 25 years, you'll remember we used to describe the person and paint the picture of your life living in that house. I will tell you guys, you really need to really just describe the property. All right. We are going to cover the next slide. In the next few slides, we're going to cover points of practice as an agent. What are some things you can do to put your best efforts to make sure to not be the subject of a fair housing complaint and protect yourself? So we're going to cover a lot of these issues, and then we're going to take a break, and then we're going to continue on. So points of practice as an agent. There are a lot of areas that you need to be cautious of what you're doing and keep in mind fair housing laws. You guys are in the business of housing. So this is a very important topic for you. You have to be careful in your communication and interaction with others. That includes the public as well as your co-op agents, brokers, your closing attorneys, your mortgage lenders, your inspectors, your home warranty representatives, your appraisers, any and everybody involved in a real estate transaction, property managers, so forth and so on. Additionally, there are points of practice you need to be aware of with respect to your paperwork, with respect to your appointments, and with respect to your marketing and advertising. The point is same. Have the same communication. You need to treat every prospect, customer, client, and again, co-op agent. I need to add to this slide. Co-op agent, closing attorney, lender, so forth and so on, the same. You need to use the same lingo. You need to demonstrate the same effort. You need to indicate the same form of communication. You need to use the same scripts. You need to provide the same information. You need to use the same policies and procedures. What I mean by this is there are some people, due to a variety of issues, where you will share your cell phone number and other potential customers or clients where you will not share your cell phone number. And the sharing of your cell phone number could be due to any number of reasons. But with respect to keeping in mind fair housing laws, If you're going to share your cell phone number with one client, you need to share your cell phone number with all clients so that you can't be charged with potentially discriminating against someone by not being comfortable sharing your cell phone number with a client that could be interpreted as you're not doing it based on one of those protected groups. Equal interaction. You need to demonstrate equal respect for all. You need to demonstrate equal enthusiasm for all. You need to show equal service, equal availability of your time and attention. You need to share equal information, and you need to be able to demonstrate equal delivery method of information and communication. Again, if there is one client or customer where you're going to go preview a property before showing, then you need to preview property for all of your clients and customers. If you are available in the evenings or on the weekends for one client or customer, you need to be available in the evenings and weekends for all clients and customers. Now, obviously, if you're going on vacation, so forth and so on, that's a different issue. But you cannot change how you go about the practice of real estate for anybody to avoid potentially being charged with discrimination against fair housing laws. So what do? You guys, you need to systematize your real estate practice as much as possible. And this is not only for those of you who work with landlords or do property management. There's a lot of times this has to do with, again, your residential resale, whether it be residential resale or residential new construction. And sometimes you might be put in a position where you've never done tenant procurement, and you'll have a seller or past client who decides they don't really want to sell their house, they just want to rent it out. You were their agent, you are their known, loved, and trusted agent. They ask you to help them list their property for rent, and you say, sure, no problem. All of a sudden, you are in a whole nother arena that you may or may not have any experience with or expertise with, and could very well get yourself and that seller in trouble by accidentally violating fair housing laws. Not only that, you guys, there are public people who know these laws a lot better than you do. And they make a living by suing you and winning and earning a judgment, getting awarded a judgment from a court. And that's how they make a living. Additionally, HUD, the Department of Housing and Urban Development, they've got quote unquote secret shoppers who will contact you as the agent and ask you questions about a property that you have listed for sale, you have listed for rent, you have listed for property management, or they pose as a potential buyer and will ask you all kinds of questions about neighborhoods and your practices, so forth and so on. And HUD has these secret shoppers to catch you in violation of fair housing laws. So you've got to be able to systematize your practice so as to not get in trouble financially or with respect to your license or legally. So have a list of questions that you ask every single prospect. For example, this by no means is an exhaustive list. For example, if you go on a listing appointment, you should ask every seller their reason for selling, whom the decision makers are, and are they all present. You shouldn't go on an appointment if they're not all there. Their target close date, mortgage payoff amount, known defects and repairs, so forth and so on. A buyer, type of home they are looking for, number of bedrooms and number of bathrooms they are looking for, the area in which they want to buy, their target move date, financing issues, have they been pre-qualified with a lender, so forth and so on. There is a whole sample list of questions for buyers that has been published by the Georgia Association of Realtors this summer. This is just a sample list. Do you want new, existing, or historic home? What is your price range? What is the size home you are looking for? Do you want a condominium, townhouse, detached single family home, or investment property? You guys are beginning to notice these are all questions describing the actual property, not a lifestyle question. What things do you want to live near? How far away from those things do you want to live? For example, work, family, medical facility, recreational area. How many bedrooms would you like to have? Do you want to live in a single floor or multi-floor home? Do you want a yard? And if so, how large? You guys, if you're going to ask, for example, if you're going to ask this, do you want to live in a single floor or multi-floor home? If you're going to ask that to one, you need to ask that to all. You can't ask that just because you are now working with a public person that is in a wheelchair or is missing an appendage. If you ask that just to someone who's in a wheelchair and don't ask that to everyone, guess what? That could be perceived as a violation of fair housing. Do you want a yard? If so, how large and what type? Do you want a pool? Is there a particular style of home you want? For example, traditional, contemporary. Do you want an open floor plan? Do you want a home with a basement? Do you want brick, wood, vinyl, or stucco-sided home? Do you want to be near a particular road, highway, or public transportation? Do you want to live in an urban, suburban, or rural setting? Is there a specific school district you want to live near? So notice you're asking the school district, you're not referencing children, because there are some people who may not have children who want to live in a particular school district for investment purposes, for example. Is ceiling height important to you? Do you want an eat-in kitchen? Do you have any special desires or requirements for the home you buy? Do you have a list of must-haves or would like to haves? Again, you can go to the Georgia Association of Realtors site for more of these questions. So again, moving on with, you must have a systematic buyer and listing appointments. You should have a what we used to call, I don't practice anymore. I am just the broker of Maximum One Greater Atlanta Realtors. So I am a broker and I am the director of the school. So I teach and broker. I don't practice real estate anymore. I'm a non-competing broker. But when I was practicing, and yes, it was 25 plus years ago, I used to have, and I encourage every agent to have a kit or a series, a set of documents that you have already pre-prepared for any listing appointments you go on and for any buyer appointments you go on. And for listings and for buyers too, actually you would have two kits, a quote-unquote pre-listing kit, as well as a kit or folder that you would have when you're actually on these appointments, as well as a pre-buyer kit that you would send to buyers before meeting with them in person, and then another kit or folder with documentation and handouts that you would have when you actually met with your buyers in person. I strongly, strongly, strongly suggest that you have these folders or listing and buyer kits put together so that they are consistent, same, and equal. And in those kits, for example, for a listing kit, you want to have an interview form. That would be a form where you have those list of questions, and then you can, so that you're assured of asking the same questions to every prospect, and then you can write down the answers. You're going to have a listing agreement and a seller net sheet. You're going to have a marketing plan. You're going to have consumer brochures. You're going to have your company's affiliated business disclosure and wire fraud disclaimer. You are going to have a property disclosure form, community association exhibit, lead-based paint exhibit and pamphlet. You're going to have fair housing information. Those are just some examples. For a buyer kit, again, you're going to have an interview form. You're going to have a buyer brokerage agreement and estimated cash to close worksheet. You're going to have a sample contract. You're going to have consumer brochures. You're going to have your company's affiliated business disclosure and wire fraud disclaimer. You're going to have a vendor list. You're going to have fair housing information. Again, I would suggest having a vendor list for your listing kit as well. So these are in your consumer brochures, you guys. You can get those from wherever it is that you access your contracts, from RDocs and FMLS, which is soon to be Remind Docs. You guys make sure you get familiar with Remind Docs now, because RDocs is going away. Or if you're using Georgia MLS Transaction Desk, there are a ton of consumer brochures in both the GAR packages as well as the RE forms packages. There are additional consumer brochures on the HUD.gov website, EPA.gov website, fair housing websites. There are all sorts of brochures that you are going to want to keep in each and every folder that you're going to hand out to your public to make sure that you can demonstrate same and equal. Also, you are going to want, as a point of practice for you as an agent, you're going to want to have consistent business policies and procedures. One of my mentors, as I was practicing real estate, always used to say, this is how I work. This is how I work with sellers. This is how I work with buyers. This is how I work with co-op agents. This is how I work, period. I am a professional. This is how I run my business. And I do not change my policies or procedures based on the price home, based on the buyer, based on the co-op agent, based on the time of year, based on the location of the property. But this is how I work. And I encourage everyone, in order, as an agent, in order to protect yourself from potentially violating any fair housing laws, that you do have a consistent, that you have consistent policies and procedures. Not only that, I actually encourage you guys to write them down. Nothing is an issue until it's an issue. But if you are facing an investigation by the Georgia Real Estate Commission, by the Department of Housing and Urban Development, by your broker, by an attorney, by an arbitrator, by a mediator, if you are involved in anything, you will be better protected if you can demonstrate in writing that you have a set business policy and procedures written down, consistent, demonstrating that consistently, this is how you work, this is how you interact with others regardless. If you can demonstrate that you have that written down, you are by far more than likely going to be much better protected should this come to any sort of investigation. So for example, here are just some examples of your own policies and procedures. And this could be in concert with your broker's policies and procedures, but create a manual for yourself. For example, I only accept calls between 8 a.m. and 9 p.m. and be equally available for all. Now, this time frame could change based on if it is during standard time or daylight savings time. We just passed the autumnal equinox, so from now through December, the days are going to get shorter and we are going to have less and less daylight each day. So your hours of operation could be a different time frame, could be limited during standard time and expanded during daylight savings time when we have daylight going later on into the evening. If that's the case, you need to have that written down. I always meet buyers at the office for the initial meeting. Sounds good, but if you're not doing it, don't include that as part of your own personal policy and procedure manual. I only show properties to pre-qualified buyers. If you do it for one, you must do it for all. I ask for identification from every buyer. Again, if you're going to do it from one, you must do it for all. There are sometimes you might meet a buyer and you get that gut instinct, you get something going on that you can't exactly put your finger on that gives you an uneasy feeling, and you might ask for their identification. Totally get that. Totally want you to be safe. But if you're gonna ask for identification from one party, from one buyer, you must just go ahead and incorporate that as part of your policies and procedures manuals for how you work with buyers. Guess what? If you've got a legitimate buyer and you explain to them why you're doing that for realtor safety, or that it's your broker's policy, a legitimate buyer who wants to hire you to help them buy real estate, rent real estate, is going to completely understand and comply. If you've got somebody that has an objection to doing that, then you might not want to work with them. I only show or list properties in blank area, as those are the areas in which I have expertise or knowledge. I market properties on FMLS and Georgia MLS and the internet, but do not do any print advertising. I do not hold open houses. When I am unavailable, the agent who covers my business is. If you ever have any issues, my broker is, etc. Again, these are just some examples for you guys to create for yourself a business policy and procedure manual, so to help you with your consistency. Now, if your public people, your public buyer, seller, landlord, tenant, ask you questions. Hey, is this a good neighborhood? What do you think of this neighborhood? What are the demographics of this neighborhood? Would you live in this neighborhood? They ask you all kinds of questions. You need to keep your personal opinion out of the answers. If they ask you, what would you do? Would you live in this neighborhood? You guys, you really need to refrain from answering that question so as not to potentially violate any fair housing laws. You must provide objective you don't have to provide them, but you would want to point your public people towards an objective resource for information. Online, police departments, chambers of commerce, published reports, MLS statistics, schools themselves, so forth and so on. I would encourage you to have your public person go to, if they want demographic information, go to these other places for that demographic information. School reports, go to the schools for the school reports. Crime statistics, ask the police department or look online for crime statistics are generally speaking public and usually published online. School information or rank, vendor lists, loan type information, county information. For example, what are the property taxes, zoning, development? In other words, do not, well, two things. One is, like I said, if a client asks you that, you have to be careful. Do not do your client's due diligence for them either. And if you are going to provide this information for one, you would have to provide it for all. I would be very, very cautious about providing school reports or demographic information, because you might have a client looking or listing in an area where they don't have the same type of demographic information published for that area as they would for another information. Now, there is a lot of information. There is that No Atlanta magazine that it is divided into areas. That might be an interesting publication to keep with you for in your listing kits and your buyer kits. But I would be very cautious about providing this information, rather than, because you may not be able to provide it for all buyers or all areas in which you work. I would just be able to point to your public people, give them places where they can go find it. Now, a vendor list, for example, for things like lenders, closing attorneys, home inspectors, radon inspectors, stucco inspectors, asbestos inspectors, home warranty companies. You can provide a vendor list for that. just make sure you are providing the same vendor list to all of your public people, and make sure that it does remain updated and that you have more than one contact person on there for any one type of industry. Example, if you're going to have one inspector, you need to have more than one inspector. If you're going to have one lender on your list, you need to have more than one lender on your list. Again, I would be cautious about you giving this information out, because you have to be able to give it to all. Also, you have to be cautious. I have on here, do not use data sources to discriminate. What I mean by that is you have to be very careful in what you say. A lot of what you may have heard is, if your public people ask you about either the demographic makeup of a neighborhood, or a child versus adult makeup of a neighborhood, or a racial makeup of a neighborhood, sometimes you may have heard that you will hear that it's okay as an agent to tell the person, look, why don't you drive by that neighborhood when the school bus is letting out? Or why don't you drive through that neighborhood and check out the makes and models of the cars that you see? Number one, you have to be very cautious. That is absolutely, through that suggestion, a potential violation of fair housing laws by showing a discriminatory or implying a discriminatory preference towards or against a neighborhood. Demographics could be by the kinds of cars. School bus could be either a violation of familial status or race or national origin. You guys, you have to be careful of what you say to a person without saying something to a person. Additionally, where I have do not use data sources to discriminate, if you are going to suggest that a buyer, for example, look up the demographic or crime statistic information of a neighborhood, if you're going to suggest that to someone when they're looking in one neighborhood, you need to suggest that to all people. If you're working with a buyer and they're looking in a neighborhood in a subdivision in one section of town, and you don't say anything about it, and then they look for a subdivision that you feel might have crime, and you say, hey, you might want to go online and look up the demographic or crime statistics for that neighborhood. Again, if you're not going to suggest it for every single neighborhood, that could be a violation of fair housing by discriminating, even by suggesting that they look up demographic information in one neighborhood versus another. And again, you guys, remember, there's people out there making money off of winning these lawsuits, and HUD is doing secret shopping. Okay, before we move on to service animals, I think this is a good time to take a break. Thank you. I'm glad you guys are enjoying the information. So I am going to stop my screen share. Hello, hello, welcome back. It is 11:01. We are going to take a 15-minute break. So everybody go take a break. I'm going to get something to drink actually, and we're going to come back at 1/4 I am going to take a break for a minute of myself to go get something to drink. I will be back before 1/4. I will answer some questions. I'm going to launch the course evaluation, and then we will finish up everything. If you get back before I do, when you return from break, once again, please enter in your name, email address, and license number. All right, everybody, go take a break and be back at 11:15 a.m. Now, all right. Just like you do in any continuing education class, there is a course evaluation. For the Zoom classes, I am going to launch a poll. So you will see appear on your screen, you're going to see a poll, and it has a series of 4 questions. Once you scroll through and answer all 4 questions, at the bottom, you're going to see a submit button that lights up, and it says submit right now, but it will actually be activated once you scroll through and answer all 4 questions. Then it will turn blue. You can hit submit, and the course evaluation will disappear from your screen. If you can't figure it out, that's quite all right. Don't worry about it. Just hit at the top of that poll. You'll see a little minus sign, a box, and then an X sign. You can just X out of it or minus it to get it out of your way. Once it's launched, I cannot relaunch it. So just do the best you can. It will stay up through the end of the class. And I appreciate everything, and we are going to continue on. All right. And again, I'm going to put in the chat one more time the request to type in your name, email, license number. Handouts are available if you go to eagentweb.com, www.eagentweb.com. You're going to click on the box that says training videos, and then simply scroll through to find this class, and you'll get, I am recording this class, so you'll get a video recording for a reminder, as well as links to PDF handouts of all, PDF versions of all the handouts, including this PowerPoint, will be available to you by PDF. Additionally, if you want to see future classes from the Georgia Real Estate Academy, if you go to that same site, www.eagentweb.com, and you click on calendar, you will get the training calendar. If you click on, once we start having classes back in person, you can click on a geographic area to actually attend a class in person near you. But while we are having virtual classes, which we will have through the end of the year, if you click on Marietta, you will get the virtual calendar for all of the virtual classes. All right. And we are going to get started. So I hope everybody is doing well and learning a lot of information. And give me 1 second, and we are going to, I'm going to share my screen again. I'm going to mute everybody.
On that, Dana, can you answer my question? There is a course on Friday, the 25th, from 10 to 11 p.m. to 1 p.m. on the calendar, but there is no indication whether it's a free 3-hour credit.
Yes, it is for 3 hours of CE credit.
Okay, thank you.
Yeah, if you go on, I apologize for that. If you go on and register that, you will see. But yes, that is contracts, offer, and acceptance. It's basically a contracts 101 class being taught virtually, and that is for 3 hours of CE credit. All right. Thank you, guys. And I'm going to share my screen again, and we will get started back. All right, let's make sure everybody can. It looks like everybody can see this. All right. We talked about that. All right. Service animals. My goodness. What an issue, right? So, what about service animals? What about animals in general? Well, you guys, let me get this out of the way for you. Okay, there are a lot of different types of animals and categories of animals when we are talking about housing, whether that be purchasing or renting. The issue of service animals, assistance animals, and emotional support animals comes up typically more often in rental situations. However, it absolutely does come up in sales situations, particularly if you consider that The homeowners association has, for example, a covenant or a restriction against, a lot of times what we see in some condominium or townhouse, or just generally speaking, there are some HOAs in their covenants and their bylaws, they have a restriction against dogs over 60 pounds. That's just a sample. So what about if a person who wants to purchase a property in that where the property, you have to join the HOA. What if you have a service animal, assistance animal, or emotional support animal that weighs more than 60 pounds? Can you be sanctioned by the HOA, or can that seller not sell to you? So again, this issue typically comes up more in rentals, but it absolutely does come up in the sale aspect of our industry as well. So there is another broad well, it's still part of this, the disability discrimination. That is refusal to make accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. That would be considered disability discrimination. So what is considered a disability? Well, under the Fair Housing Act, a disability is defined as a physical or mental impairment which significantly limits a person's major life activities. Even, for example, if a lease says no pets or restricts pets, and again, that would be weight, species, type. There are some where there are certain breeds of dogs, for example, that may or may not be restricted. So even if a lease says no pets or restricts pets, landlords are required to make what is called a reasonable accommodation to allow pets who serve as assistance animals, which includes animals who provide emotional support. You guys, I'm going to tell y'all right now, this could be a whole 3+ hour CE class on assistance animals, service animals, emotional support animals, in addition to what constitutes a reasonable accommodation and under what circumstances does a landlord, or I'm not going to use the word landlord, I'm going to use housing provider, have to make those reasonable accommodations. So I just want to bring it to your attention because it's important and it's relevant for, we're seeing more and more issues with service animals, emotional support animals, and assistance animals. So I want to bring to your awareness a little bit of the background. But again, you guys are going to have a ton of questions, and this could be a whole nother class in and of itself. So what are the obligations of actual charging pet deposit? Just hang on, I see that question. I'm going to get to that a little bit later on. What are the obligations of housing providers? Individuals with a disability may request to keep an assistance animal as a reasonable accommodation to a housing provider's pet restrictions. Housing providers cannot refuse to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. The Fair Housing Act requires a housing provider to allow a reasonable accommodation. You guys, I'm using the term reasonable accommodation. That is, again, there are very specific measures that may be required of a housing provider to quote unquote provide what is defined by HUD and by the government as a reasonable accommodation. So the Fair Housing Act requires a housing provider to allow a reasonable accommodation involving an assistance animal in situations that meet the following conditions. A request was made to the housing provider by or for a person with a disability. The request was supported by reliable disability-related information if the disability and the disability-related need for the animal were not apparent and the housing provider requested such information. Be careful, be careful, be careful. And the housing provider has not demonstrated that granting the request would, so in other words, the housing provider does have to make these accommodations unless the housing provider has not demonstrated that granting the request would impose an undue financial and administrative burden on the housing provider. The request would fundamentally alter the essential nature of the housing provider's operations. The specific assistance animal in question would pose a direct threat to the health or safety of others, despite any other reasonable accommodations that could eliminate or reduce the threat. The request would not result in significant physical damage to the property of others, despite any other reasonable accommodations that could eliminate or reduce physical damage. So again, that is a whole nother series of tests and evaluations and questions. A lot of the questions are, instead of doing A, could we do B and provide the enjoyment of the living situation? Okay, let's move on a little bit. We're still in the same realm, but what are assistance animals? And I have that term in quotes. Assistance animals are in a different legal classification than pets who are not assistance animals, which is why pet restrictions and fees, there's your question, are waived. So you cannot charge a pet deposit for an assistance or service or emotional support animal. But if that animal does damage the property, you can require the tenant to pay for repairing or replacing that damage. But you absolutely cannot charge a pet deposit, because an assistance animal, emotional support animal, and service animal are not pets. Therefore, a pet deposit does not apply. Assistance animals are animals that work, assist, and or perform tasks and services for the benefit of a person with a disability, or provide emotional support that improves the symptoms of a disability. There is no official certification or training for assistance animals, and they can assist in a wide variety of ways. Breed and weight restrictions do not apply to assistance or service animals. So there is a difference between a service animal and an assistance animal. Now, a service animal, those animals are categorized as animals trained to do a specific task for their owner. For example, a guide dog. That's the most common, most widely recognized service animal would be, for example, a guide dog. But there are all kinds of service animals. Service animals are allowed in public accommodations because of the owner's need for the animal at all times. There's all kinds of other service animals. For example, for people that have seizures, a lot of times due to epilepsy, or have diabetes where their blood sugar changes rapidly and impairs the person at a moment's notice, there are a lot of service animals that can detect those changes, an oncoming seizure or an oncoming drop in blood glucose, insulin, so for diabetics. So there are all kinds of service animals. An assistance animal, on the other hand, and service animals can be more than dogs, but typically we do see more service animals that are dogs than any other breed. An assistance animal can be a cat, dog, or any other type of quote-unquote companion animal, and does not need to be specifically trained to perform any kind of service. The emotional and or physical benefits from an animal living in the home are what qualify the animal as an assistance animal. A letter from a medical doctor or therapist is all that is needed to classify the animal as an assistance animal. The fact that the term service animal is often used by landlords and public housing authorities to refer to both service dogs and assistance animals a lot of times really does create a lot of confusion. So what are some examples of assistance animals? A cat who can detect and alert their companion to oncoming seizures. Again, that type of disability, there are certain service animals that also serve that function, but there are some assistance animals that can detect oncoming seizures as well. A dog who alleviates a person's depression or anxiety. A cat who reduces a person's stress-induced pain. A bird who alerts their hard of hearing companion when someone has come to the door. I'm using pretty domestic, commonly thought of pets in these examples: cat, dog, bird. However, you'll see a little bit later, I've got a video to show you guys. It does not necessarily have to be a domestic household species that could meet the definition of an assistance animal with respect to fair housing. So it is illegal for someone, whether a public landlord, seller, or you as an agent, to ask about the existence of a disability in this way. It's illegal if you ask an applicant if they have a disability, or if anyone living in the property has one, or if anyone associated with someone who wants to rent or live in the property or buy has a disability. It is illegal to ask the nature or severity of the disability. And it is illegal to ask of proof of the disability. Those are all illegal. But it is legal to ask of an applicant's ability to meet the requirements of tenancy. It is legal to ask if the applicant is a current illegal abuser or addict of a controlled substance. So you can ask, again, do you think you're going to get a truthful answer? Don't know. It is legal to ask if applicant qualifies for a property legally available only to persons with a disability. So Christine, I see your question, and we have more to cover with this topic. A provider may request information necessary to evaluate if requested reasonable accommodation is necessary, but be cautious. So again, your landlords may ask, you can't ask for what the so here's a very subtle difference. You may not ask for proof of the disability, but you may ask if they qualify for a property available only for disabilities. And when it comes to the animals, well, you'll see, a provider may request information necessary to evaluate if requested reasonable accommodation is necessary. So in this part of the class, what we're talking about, before we were talking about reasonable accommodations, which included lots of physical changes to the property. And I didn't specifically point them out, but one definition of making reasonable, that a housing provider must make a quote unquote reasonable accommodation so as not to violate fair housing laws, would be, for example, to add a ramp onto the property, or to add the grab bars in the restrooms of the common area bathrooms, or to, like the quiz question, have environmental issues such as light switches and thermostat controls at a level where someone could reach in a wheelchair. So those are some sort of physical alterations to a property that a housing provider may legally have to make the property, to make it a reasonable accommodation. Allowing the existence to dwell inside the property of a service or assistance animal is another type of quote unquote reasonable accommodation that a housing provider may be compelled to have to allow so as not to violate fair housing. So a provider, if a potential tenant or potential buyer, usually again these are made with rental situations. If a potential tenant makes the request that the landlord or HOA, for example, allow the reasonable accommodation to allow me to have my 80-pound dog live with me in the dwelling, even though you have a covenant against dogs or animals over 60 pounds, you may be required legally to have to make that quote unquote reasonable accommodation for me to not violate my fair housing. So if that request is made of me, then as a housing provider, i.e. landlord, I may request information to evaluate that. So I may request information necessary to verify the person's ability to meet the Fair Housing Act's definition of a disability, which is a physical or mental impairment that substantially limits one or more major life activities. This applies for requested accommodations and service or assistance animals. So then, the demonstrating that the animal is an assistance animal, the tenant should provide the landlord with a letter from the doctor or therapist stating that you have a disability. It doesn't have to say the nature or specificity of that disability, but just stating that there is a disability and explaining that the pet, I should not use the word pet there, that needs to be changed to animal, that the animal is needed to help you cope with the disability and improve the symptoms of that disability. Again, you do not have to specify what that disability is. Attach a brief personal statement explaining to the landlord that you're asking for a quote reasonable accommodation to keep your, again, that should be animal, who functions as an assistant support animal. Landlords must agree to reasonable accommodation requests if the disability claim is true, and if the request does not create a hardship on the landlord or other tenants. If your request for a reasonable accommodation is denied by the landlord, you have the right to request that a government agency investigate your claim that the landlord is discriminating against you. So this term here, create a hardship on the landlord or other tenants. So the landlord's rights, and okay, let me back off just a minute. There are service animals and there are assistance animals that absolutely are working animals that help people with a physical disability, a mental disability, stress, PTSD, all kinds of stress, all kinds of emotional support, as well as, so there are absolutely these assistance animals and service animals and emotional support animals who provide a huge service to humans. And those humans, there are many humans who need that support and that assistance and that service. There are other humans who try to use these laws to just allow a pet to live with them in a dwelling when that pet would otherwise not be allowed to live there. So don't get me wrong, there are both sides of this issue where the tenant buyer has rights as well as the landlord and other people living in that area also have rights. So it's a very, very fine line between somebody just trying to use the laws to their advantage versus somebody who really does need these animals and wants to live there. So again, there is a whole series of very specific questions and answers or tasks to evaluate the demonstration and evaluation and certification of an animal to qualify for a service animal, assistance animal, emotional support animal. There are a series of questions depending upon if the disability is observable or not observable, apparent or not apparent, if an animal work task is identified or not. There's information from a licensed healthcare professional. They look at the relationship between the disability and the need for assistance. They look at, is the animal commonly kept in households or not? Is the animal a unique animal? Okay, one question is, would the request for a service assistance animal have to be made prior to the rental if they are aware of the disability before renting? I don't know the answer to that question. In other words, I think what you're asking is, if I have an emotional support animal, but I don't fill that in on the application, and then I move into the property and all of a sudden I've got an animal living with me, do I then have to prove, can I do that? The answer more than likely is, if the landlord wants to evict that person, all of these issues are going to be brought up, and more than likely the landlord will not be able to evict that person. But on the other hand, had that person had the tenant disclosed that beforehand, the landlord cannot not rent to them because of that anyway. So very interesting question. Would a seller be required to put in a ramp at their cost if the seller says no? A seller would not have to alter the property by putting in a ramp. Now, well, I take that back. A single family seller would not. A multifamily unit, if it is fewer than 4 properties, would not. If it is a seller that owns a unit that is more than 4 units, I believe they would, maybe. And so I think it depends. I don't think that's a black and white question, Christine, about putting in a ramp or not. But I don't believe, for example, single family properties, not multi-dwelling, would have to do that. And for multi-dwelling, it might have to be for common areas where the HOA would have to put that up, and not necessarily the individual seller. That's a great question, and I would have to find out the answer to that. So again, I think it depends on the number of properties. Okay. So there are a whole unique series of questions, and the answers of those questions, depending on what those answers are, determine whether reasonable accommodation to allow an assistance animal must need to be made or not. And again, it depends on the answers to all of these questions. There's a whole series of questions based on each one of those issues. Now, let's talk about certification. So, there is no such thing as a certificate or certification program that officially qualifies a dog as an emotional support animal under the law. The only legitimate way to qualify your dog, and again, it could be any animal, I'm just using dog in this slide, as an emotional support animal, is by obtaining, as we already mentioned, a recommendation letter from a licensed mental health professional. If you don't have a therapist, or if someone is having trouble finding one, there are lots of platforms online where you can meet with a mental health professional and get this recommendation letter. A landlord or anyone else that asks you for a registration number, certificate, or ID proving your dog is an emotional support animal is misinformed. The only proof you need is the ESA letter written by a licensed professional stating your need for an emotional support dog, or again, that could be any animal. Going back to the question about the landlord and emotional support animal or guide animal or service animal, that might be something that a landlord would want to include on every single application that they have, so as to know going into an application whether a person has one or not. And again, you can't not rent to someone based on that, but rather than being finding out later, you know, that would probably be a question, especially nowadays, to include on that application. To be absolutely clear, if you do obtain an ESA letter, emotional support animal letter, you are also not required to, quote unquote, register your animal on any website. Fair Housing and Air Carrier Access Act rules do not recognize certifications or registrations of emotional support animals. However, guess what? I went to Google and I put in certification of emotional support animal. And these are the first 3 things that I got. There were ads and there were other real information after that. But look at that. Emotional support animal. Make your pet an ECA in 24 hours. Letter from our therapist now. Quick process. Get your pet certified as an emotional support animal in 15 minutes, 24 hours a day. And look at the next one. Instant ESA letters, same day, only $49. Look at the next one. Certify your dog for $14.99, same day approvals. So again, there are people that will use the law to their advantage when they want to live, well, 2 things. When they want to live somewhere where they don't allow pets and they have a pet, well, then they can use the law to their advantage. And then there are others that actually need these service animals. So you have to be extremely careful about what you ask and how you ask and what you ask for. So again, there are steps. If it is an actual service or assistance animal, there are steps if it becomes an issue. And again, nothing's an issue till it's an issue, but if it becomes an issue, there are steps to be taken. There's an intake process. There's the complaint. I have compliant, but that should be complaint, and an interview process. Then if it is deemed that there is a viable complaint, there's an investigation process by the Department of Housing and Urban Development. Then there's conciliation or voluntary compliance. And then if there's no conciliation, or that would be, for example, agreement between the parties, or voluntary compliance, then there could be legal action that would result from that. So pet fees, again, service and assistance animals are not technically pets, and owners do not have to pay a pet fee. The landlord, however, can charge a security deposit and may still seek money from the tenant if there is any damage caused by the animal to the home. Also, if there is a nuisance issue, the landlord does have the right to try to remove the assistance animal through legal proceedings. Now, the other thing I want to let you guys know, although there is no required certification or registration that you would have to ask for, the animals do have to be, for example, if it's a dog, they do have to have their current shots and immunizations for a domestic animal. Now, let's look at the contract forms. In the Georgia Association of Realtors, or GAR, in their pet exhibit, which is used on leases, which is GAR form F810 pet exhibit, it does have a section that says service animals or emotional support animals. It has a place for both the resident's initials and the owner's initials. And it says, owner does not require a pet deposit or fee for a service animal or emotional support animal as defined by the Americans with Disabilities Act as amended. There is no restriction regarding the service animal or emotional support animal with respect to the animal's breed or size. However, the owner of the animal is liable for any damages caused by the animal above and beyond, for the animal above and beyond the normal wear and tear a human tenant might reasonably cause. This includes teeth marks on trim, carpet torn by dogs digging, and carpet soiled by dogs' waste or vomit. And then it has a place where it has service animal, emotional support animal description, and registration number if applicable. Now, in the RE forms, the pet exhibit RE240, this is service animals and emotional support animals are not addressed because this is only an exhibit for pets. All right, you guys ready for this one? This is gonna, well, I'm curious to hear what you guys what you think about this. So let's watch this video. Reading some of the chat questions. Nope, it's not a joke. That is serious. Not a domesticated animal. Remember one of this series of questions that would be evaluated should this go further. There are questions for domestic animals and quote unquote unique animals. So this would qualify as a unique animal. Tiger King better watch out. Great day to be a UGA fan. Hilarious. Would the neighbor have to disclose what lives next door to them? No, I am not aware of any laws where one neighbor needs to disclose anything to another neighbor. What happens when he grows up? Bites someone's, okay, so if that gator were to bite someone's finger off, again, that would be a good example of what we talked about earlier in the class regarding a quote-unquote direct threat. An alligator biting someone's finger or hand off would absolutely, I believe, meet the definition of a direct threat. Yeah, donations for legal fees. Yep, interesting. Very interesting. Okay, Christine, great question. VRBO and Airbnb, they are definitely considered quote unquote housing providers. It is a rental. It is a short-term rental, but those are rentals. And those housing providers must also comply with these laws. You guys, these are federal laws and state laws. So yeah, whole interesting situation. And for those of you, I see a lot of familiar faces. For those of you who have taken my classes before, especially my contract classes, you guys know that nothing's an issue till it's an issue. What if a neighbor has a phobia? Disability for dogs or gators. That would be a good lawsuit. I am not sure how to answer it. The neighbor doesn't have to be the gator. They don't have to go and be in touch with the gator. I don't know the answer to that question, but I thought you guys would enjoy the federally licensed emotional support alligator. All right, we're coming into the home stretch. So give me 1 second. Oh, shoot, what happened? No,
healthcare is an economic.
All right. Need to go to the next slide. There we go. All right. So let's switch gears just a little bit. What does the National Association of Realtors, or NAR, what are some of their stances or publications or marketing on fair housing? Fair housing is more than a list of do's and don'ts, rights and penalties, and mandatory continuing education. As stewards, you guys, as a real estate agent, you are a steward of the right to own, use, and transfer private property. That is part of what you agreed to when you agreed to go get a real estate license and help the public with their buying and selling needs. You are a steward of a public's right to own, use, and transfer private property. Fair housing protects your livelihood and business as a realtor, and depends on the free open market that embraces equal opportunity. Realtors recognize the significance of the Fair Housing Act and reconfirm their commitment to upholding fair housing laws, as well as their commitment to offering equal professional service to all in their search for real property. Also, while we're on NAR, I apologize. When we were talking about the sexual orientation as a protected group, not under our federal or state laws, but if you are a realtor by virtue of your membership into NAR, I just addressed the NAR articles of, what am I trying to say? Code of Ethics, I apologize. And we just addressed Article 3, but under the duties to public, I neglected to mention this. She mentioned it in the video we watched, but Article 10 does specifically say that realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of race, color, religion, sex, handicap, familial status, and national origin, sexual orientation, or gender identity. And realtors in their real estate employment practices shall not discriminate. So it is addressed in a variety of ways in the Realtor Code of Ethics regarding your interaction. So I just wanted to bring that up because I did neglect to say that at the beginning. NAR does have a Fair Housing Action Plan, and it is abbreviated ACT, which emphasizes accountability, A for accountability, C for culture, and T for training. That is in order to ensure that America's 1.4 million realtors, that number give or take depending on what's going on, but are doing everything possible to protect housing rights. And you guys, where it has 1.4 realtors, those are just real estate agents who belong to NAR. There are a lot of other real estate agents who practice real estate but do not belong to a board, therefore do not belong to NAR. So there are more than 1.4 million people practicing real estate agents. It's just that of those people practicing, 1.4 of them do belong to NAR and can use the term realtor as applied to their profession. Also, NAR suggests that all agents and brokers print a copy of their Realtor Fair Housing Declaration and post it in your office and or association. I encourage you guys, remember we were talking about those listing kits and buyer brokerage kits. I encourage you guys to go ahead and print out this Fair Housing Declaration and post it in, keep it as a handout in your kit as well. There is a handout available to you where you can access the handout. And this is what the NAR Fair Housing Declaration states. It says, I agree to provide equal professional service without regard to the race, color, religion, gender, sex, disability, handicap, familial status, national origin, sexual orientation, or gender identity of any prospective client, customer, or the residents of any community. I agree to keep informed about fair housing laws and practices, improving my clients' and customers' opportunities and my business. I agree to develop advertising that indicates that everyone is welcome and no one is excluded, expanding my clients' and customers' opportunities to see, buy, or lease property. Inform my clients and customers about their rights and responsibilities under the fair housing laws by providing brochures and other information. Again, you guys, those brochures are available to you through the GAR contract form packages, the RE forms contract packages, as well as HUD.gov, EPA.gov, and if you Google fair housing consumer brochures, you'll get a gazillion of them. I agree, this is continuing on with the NAR Declaration, Fair Housing Declaration. I agree to document my efforts to provide professional service, which will assist me in becoming a more responsive and successful realtor. I agree to refuse to tolerate non-compliance. I agree to learn about those who are different from me and celebrate those differences. I agree to take a positive approach to fair housing practices and aspire to follow the spirit as well as the letter of the law. And I agree to develop and implement fair housing practices for my firm to carry out the spirit of this declaration. So there are a lot of resources for you guys. There is DCA, which is the Department of Community Affairs in Georgia. So that is going to be a very useful resource for you regarding your practice with respect to your Georgia real estate license. There is NAR, which is the National Association of Realtors. And under NAR, there's a lot under fair housing. You go to one section of fair housing and you'll find a lot of the stuff that we've just discussed in this class. You'll find a whole separate section on assistance animals. You'll find a whole separate section on renting versus the sales. You'll find a whole separate section on reasonable accommodation. The DOJ, the Department of Justice, has a whole section on fair housing. HUD, the Department of Housing and Urban Development, again, they have a number of pages online regarding fair housing. Again, with respect to everything, rentals, sales, animals, reasonable accommodation, physical reasonable accommodation. They have resources for real estate professionals as well as resources for the public. There is the National Fair Housing Alliance. There is HUD specifically on assistance animals. There is the ADA, the American Disabilities Act, has a whole ADA.gov. They have a whole section on fair housing and a whole section on assistance animals. There's the Humane Society that has a bunch of resources on housing and fair animals. So just to show you guys, for example, let me show you, let's see if this will take us here. This is, again, that's not the one I wanted. I want the DCA. Oh, you know what? I put the wrong thing. Well, shoot. I just wanted to show you guys, well, we'll go back here. This is the Department of Justice. And this has even a more in-depth explanation of what discrimination potentially looks like based on all of the individual groups. But I want to show you DCA on fair housing. And again, this is Georgia. Is it going there? Let's try one more time. Here we go. This is the Georgia Department of Community Affairs. And here is a whole section on fair housing statement. There is effective communication policy. Here's a section on reasonable accommodation, language access resources, how to file a fair housing complaint, the whole grievance procedure, fair housing resources and materials. Fair housing also applies to the lending industry, the insurance industry, so forth and so on. ADA guidelines, accessibility information, and DCA initiatives. So again, I encourage you guys to go look up and do further research on fair housing issues. Number one, it's important with respect to your real estate license. And number two, it is important to know with respect to just interacting with other people and their buying and selling needs, especially if you deal with rentals in any shape, form, or fashion. whether they be single-family properties, whether they be multifamily properties, whether you are dealing with a seller that decides to put their property up for lease and you're just simply doing tenant procurement, whether you are in the leasing industry as the main avenue of your use of your real estate license, whether you are in property management. Also, if you are working with investors who want to purchase a property and then rent, there are a number of avenues where you could inadvertently, or not even be thinking about it at this point, but be involved. Last slide for a second. Yeah. Be involved in one of these issues. Also, if you just go to Google and Google Fair Housing or Fair Housing Act, you are also going to be inundated with a ton of issues. There you go. Yeah, feel free to take a picture of this slide. And again, these links are available to you in the handouts. So I am going to share this last slide where, again, I have remembered to confirm all your contract questions, any questions, your practice questions with your broker. If you go to registerforreclasses.com, you will see additional courses offered through the Georgia Real Estate Academy, as well as we help advertise a lot of other CE courses that are offered through other schools. For example, we advertise a lot of appraisal classes that are offered through, for example, DS Murphy. We advertise a lot of classes, CE classes offered through FMLS and Georgia MLS. So all the classes that you will see, if you go to registerforreclasses.com, you click on Marietta, you will see a calendar of many virtual classes, not all offered through the Georgia Real Estate Academy, but we're just trying to get it out there for you guys so you guys can get, no Gator, you can get a lot of education during this time virtually. It does take us approximately 3 to 5 business days to record your CE credits. And I have a separate YouTube channel called Real Estate Made Crystal Clear. Obviously, I am a broker for Maximum and Greater Atlanta Realtors. So per license law, I do have to have that on my real estate channel. But the audience, my intended audience for the videos on my YouTube channel is every real estate agent in the state of Georgia. The majority of my videos are contract tips dealing with the Georgia Association of Realtors contracts and the RE forms contracts, and I cover a lot of license law issues. So please feel free to check out that channel. Feel free to subscribe. It's over 5 years old now, so you will find a lot of information on there. But again, I do refer you to your own broker for any contract issues or real estate practice issues, as well as your own broker's own policy and procedure manual. So once again, before I will be more than happy to answer any questions, either on the chat function or if you want to unmute yourself. If you are not asking a question, please keep yourself muted so that we can hear questions, and just type in your name, email address, and real estate license one more time before you leave. And I appreciate your time and attendance. I certainly hope that you got something out of this class and that it helps you be a better real estate agent. You guys, there are lots of buyers and sellers, landlords and tenants that need your services. So please go and bless them with your real estate license, knowledge, and expertise. Class on the 29th. And you renew on the 30th. We do our best, but you guys, you have 4 years to renew your license and get all your CE credits in. So we do our best to get the credits in as soon as possible. But for these Zoom classes, again, there are 3 reports that we have to put together to come up with a CE roster. So encouragement to everybody, don't wait until the last month of your 4 years to get all your CE in to renew your license. But again, as the Georgia Real Estate Academy, we do our best to log the credits in as quickly as possible. Yes, love the Gator story. I thought I thought you guys would enjoy that. I thought that was quite interesting. All right. Any other questions, anybody? Thank you guys so very much. I appreciate your attendance. I appreciate your interaction. You guys gave me some food for thought to look at regarding a seller having to build a ramp. Again, I don't think so unless they own more than 4. And as I mentioned, so forth and so on. Tenant's disclosure of an assistance animal prior to signing an application or a lease. I need to look that up. VRBO and Airbnb, yeah, absolutely. They're renting property. They're going to be have to adhere to these laws too. Do I need to call Greg for the last class? I don't know what you mean by calling Greg.
Do I need to call the real estate commission to find out if the classes are submitted, if the credits are submitted 5 days later? Will it affect my renewal?
Yes, it will affect your renewal. Your license expires on the last day of the month. So happy birthday, Beatrice. Your license, if your birthday's in September and this is 4 years, your license will expire the 30th of September if you have not completed all of your real estate.
So what, I have renewed the license, but it's waiting for the credits. Well, how will that?
Oh, okay. So you've already, you guys, this is something, I'm glad you brought that up. Do not renew your license until you have all your CE, because Greg will inactivate your license. Even if you pay, like for example, if your birthday is sometime in September and it's 4 years, you have till the end of September to renew. So a lot of agents, like what I'm hearing from you, Beatrice, you went ahead and renewed early thinking you're doing a good thing by giving the real estate commission their money. But you don't have all your CE. And I am assuming that you were thinking, well, I'll go ahead and renew now, but I know I have till the end of September to get all my CE in. Well, as soon as Greg gets your money for your renewal, if you do not have all your CE, they're going to inactivate your license, even though you had till the end of the month to do it. So what will happen is, as soon as all of your CE credits do get credited with Greg, they should, then you'll be ready to be active again. But Beatrice, you're also going to have to go back to your broker and get your broker to sign the Greg change form to re-affiliate you with the brokerage.
But right now, my license is inactive. I'm just renewing it. So will that affect me?
Yes. Have you already renewed your license?
I have renewed it, but my license is inactive. It's been inactive.
And how many CE credits do you have?
I need 3 more classes to be fine. The last class is on the 29th.
So after you take that class on the 29th and those 3 hours of CE get recorded with Greg, then you are going to have to go back to your broker and get your broker to sign a Greg reaffiliation.
No, I am not with any broker right now. My license is hung with the state. It's inactive. I'm just renewing my license.
Okay. Then your license is going to stay inactive until you find a broker with whom to practice.
Okay. All right.
But before a broker is able to pull you on board, you're going to have to complete all 36 hours, 3 of them license law.
Where I was concerned is because even though I'm not practicing right now, I just wanted my license to be okay. So if by the 30th, they don't have all of the credits in, even though I'm inactive, will it affect me in any way?
It will only affect you if you try to hang with a broker right now and practice. But if you want to keep it inactive, it will not affect you after those last 3 hours get recorded with Greg.
Okay, thank you.
Yes,
and one last question I want to ask is not related to what we have here. Somebody threw that at me yesterday, and I wanted to hear your opinion as the expert in this field. And the question is that right now he is not planning to sell, but somebody told him if he wants to sell, this is a better time to sell, that when the pandemic is over, values will come very low. What do you think about that?
I think any time is a great time to sell. I'm in the practice of real estate. You guys, there is no good or bad time. There is no bad time to sell real estate. There's no bad time to be a buyer. Markets are markets. There are people that always need a roof over their head. There are times when for a seller where there's more competition and times where there's less competition. As a real estate agent, there are times when there is more competition and more agents actively working, and there's a time when there's less competition and fewer real estate agents actually working. The market is the market, and there is always a need for listings because there are always buyers looking for houses. This has been true for many hundreds. This has been true for at least 100 years, if not more. So there is never a good time or a bad time to sell. A lot of people will say now's a great time because there's less competition. So there's a better price for houses. We do not hear from our lenders that there is going to be a mass foreclosure market like there was in 2008. The market forces in play right now are completely different. This is a quote unquote, well, it's not an organic economy right now. It is not the market economics happening because of market forces. Mortgage rates are still phenomenally low. The Fed is buying mortgages from lenders. What that means is a mortgage lender will issue a mortgage to someone, then they sell it to the Fed. The Feds then give the mortgage lender cash to go lend to somebody else. The restrictions or the underwriting criteria still remain strong. That's a big difference than in 2008, where there were a lot of interest-only loans and so forth and so on, where it was inevitable, not inevitable, but what happened was the result was a huge increase in foreclosures once that balloon payment became due and people had to pay principal and interest rather than just interest. That is not this market at all. Additionally, there are a lot of the homeowners that have equity in their houses. All right. So there's never a bad time to be. All right. Let me show you how to access the handouts and the calendar. So let me share my screen. Let me get out of there. Let me go online. So if you go online and you simply go to www.eagentweb.com, no password, no anything, it's just a URL. You are going to get this website. If you click here where it says training videos, oh man. You are going to get this page, training videos and CE class handouts. If you scroll through, you are going to find, so here's the first one, because this is the one we just had today. Know who is protected under fair housing and what the laws are. Let me make this a little bit bigger for you guys to see. And there's the notice to students. Again, the link to the video will be posted here. If you click here, for example, handout of PowerPoint slides. If you click on that, it is going to download. I have it blown up so big. There you go. It downloads a PDF of the slides that we just went through. So all of these hyperlinks you will see are handouts. There's the NAR Fair Housing Declaration. There's that infographic of trends in fair housing. There's the HOPA Act of 1995. So all of the CE classes that we offer through the Georgia Real Estate Academy are here with the handouts. And here is a video link of that class, and you click on that, it will take you to the video of that class. Now, also, if you go back to this same site, www.eagentweb.com, if you click here where it says calendar, click on calendar, and when we have in-class classrooms, you can click on a specific geographic location to see what their classrooms are. But for the actual virtual classes, If you click where it says Marietta, it will take you to this calendar, and these are going to have all of the virtual classes, regardless of the physical location where the instructor is. And it has classes through the Georgia Real Estate Academy, as well as classes. For example, this is a class that is offered by D.S. Murphy through their school. So for example, you see a class that you want. We've got 2 more tomorrow, Home Warranty Fundamentals and How to Become Lender Ready and Leverage Business Credit. And then one on Friday, Contracts, Offer, and Acceptance. So all you do is you click on that. It gives you information about the class and who the instructor is. And you click on Register here, and it will take you to an actual registration page where you fill in all the information. So I just wanted to share with you guys a little bit about how to find that information. So thank you guys.